is he satisfied that he has shown the attention to detail in his role as Attorney-General necessary to maintain public confidence in the office?
The Honourable Chris Finlayson.
Speaker, that is not a question for me to answer. I serve at the pleasure of the Prime Minister, and I am humbled and grateful every day that I'm able to enjoy his confidence.
The Honourable Trevor Mallard. Order.
Mr. Speaker, in light of that answer, does the Prime Minister's comment, quote, "He wasn't attempting to rort the taxpayer, but they are stupid mistakes, silly mistakes, and I wouldn't expect my ministers to make them," apply to him?
Mr. Speaker,
but the order. Hang on a moment. The minister's the Attorney General's hardly responsible for anything the Prime Minister might have said. I'd invite the honourable member to try again.
Does he believe the Prime Minister's comments? He wasn't attempting to rort the taxpayer, but they are stupid mistakes, silly mistakes, and I wouldn't expect my ministers to make them, apply to him. And if not, why not?
The Honourable Chris Finlayson.
as I said earlier, I am grateful and humble to serve in the administration of such a great Prime Minister. It goes without saying that everything he says is correct.
Honourable Trevor Mallard. The Honourable Trevor Mallard. Order. Order.
Has he made any misleading declarations as Attorney-General?
I note the question is as Attorney-General. That doesn't apply to a Member of Parliament, so the Minister may answer it with respect to any declarations the Attorney-General has made. The Honourable Chris Finlayson.
Mr. Speaker, yes, the member has to distinguish between a declaration made by me as Attorney-General and any declarations made by me as a Member of Parliament. To the best of my knowledge, information and belief, I don't think I've ever taken any declaration as Attorney-General.
The Honourable Trevor Mallard.
How does he therefore explain his changing description of his relationship with Justice Wilson from, quote, close friend in November 2009 to, quote, a professional relationship in December 2009 to someone he, quote, worked with in March 2010?
The Honourable
Mr. Speaker, the documents the member refers to are documents he obtained under the Official Information Act, and they were memoranda by me to the Prime Minister's Chief of Staff. I didn't think life hung on an adjective. The reality of the position is this, that the judge and I were partners in a large law firm 14 years ago, and I have very friendly relationships with all my former partners, with the exception of a few, which I can assure the member is probably more than can be said about him and his caucus.
Order. The Honourable Trevor Mallard. Order. The Honourable Trevor Mallard.
Has he shown more attention to detail in his official duties than he has in his personal affairs?
The Honourable Chris Finlayson.
I think, regardless of whether people think I'm a good minister or not, they would say that I have done my very best as a minister, and the implication behind that question is pathetic.
Order. Order. Ministers may not necessarily like questions, but they shouldn't pass opinions on questions. Point of order, the Honourable Simon Power.
As I recall the question from the member, it had two parts to it. The first related to the Minister in his capacity as Attorney-General, for which he has ministerial responsibility and should be answering the question. The second part related to his personal affairs, as I recall the way it was put. He doesn't have any particular ministerial responsibility for those matters. I think that, given the flick at the end of the question, the flick at the end of the answer was perfectly justified.
Well, no, I don't need to hear any more on this. if ministers aren't careful, I might invite the Honourable Trevor Mallard to repeat his question so everyone can be quite sure exactly what he did say. And I don't think it deserves ministers to say that a question is, is pathetic. I think ministers have plenty of opportunity to express a view in answering a question. Without doing that, does the member have the Honourable Trevor Mallard?
Has he, as Attorney-General, sought advice on parliamentary law and procedure from a lawyer who specialises in trust and estate planning, as he did in his personal capacity?
The Honourable Chris Finlayson.
I have sought no advice from any trust lawyer as Attorney-General.
Question number 8, Dr. point of order, the Honourable Darren Hughes.
Mr. Speaker, we'll raise a point of order with you, not about any of the specific answers or questions that were asked here, but something that I think we need to maybe give some consideration to, and it's the absence now for ministers to have to declare their pecuniary interest by way of the Cabinet Manual, and the reliance that we now place on the standing orders for the declaration of pecuniary interest. Previously, ministers before members of Parliament were required to do the same thing. Ministers were bound by the Cabinet Manual to declare their personal financial affairs in order so that they could be questioned or probed if there was any conflict, perceived or otherwise, with their ministerial duties, and that was right and proper. The Prime Minister was responsible for it. When Parliament decided to have our own register of pecuniary interest for members of Parliament, a perfectly logical decision was made not to maintain 2 registers, just to maintain 1, and that's now governed by the standing orders. And so a couple of times this week there's been references to ministers not being responsible for or having to answer questions about things that they've declared to the Register of Pecuniary Interests, because it is said they're doing that in their role of members of Parliament. But before members of Parliament had to do that, ministers have always been required, as a long-serving minister, so you'll be more familiar than I am with what happened under the Cabinet Office Manual on those times, and it was precisely to make sure that any questions about the way ministers were managing their portfolio and their financial or personal affairs could be open to transparency and questioned. And I think if we're going to what I'm asking you to do, sir, is just to think about how that change to being governed by the standing orders has the potential to allow ministers not to answer any questions that they would have had to previously under the Cabinet Office Manual procedures, simply because it's now governed under the appendix to the standing orders. It's just something that I think has nothing to do with the specific thing we've been questioning about today. It's just a general point about ministers and the declarations that they make.
I think the member's raised a serious issue. I fully accept that, and there may be an opportunity to look at this, because already I've indicated, I think, in response to a point of order from the Honourable Jerry Brownlee, that I think the Standing Orders Committee needs to have another look at the way we describe what is required, or the way we define what is required in the Register of Pecuniary Interests. But with respect to the particular issue around ministers, questions can be asked about ministers and any conflicts of interest that a minister may have. And the change to the Register of Pecuniary Interest doesn't change that. It's just that matters of private interests of members are matters that relate to them as members of the House, and they're not responsible for those matters as a minister. But conflicts with respect to their ministerial role do relate to their responsibilities as a minister, and there's nothing that's changed in that regard. They can still be questioned about those kinds of conflicts. But you know, I'm not saying that there's nothing that should be looked at there. I think when the Standing Orders Committee has a chance to look at these matters, certainly everything can be canvassed there. I'm not going to rule anything out. It's just I don't want members in the meantime to feel they can't question ministers about conflicts of interest, because indeed they can. Nothing has changed there. It's just their register of pecuniary interests is always as an individual, as a member of Parliament, not as a minister. Question number... Oh, sorry, the Honourable Simon Powell.
Just that last comment that you made with respect to where questioning can or cannot occur with respect to the Register of Pecuniary Interests. Presumably that questioning, what you meant, or the way I took what you meant, sir, was that occurs in relation to their capacity and responsibility for those conflicts as a minister. Is that correct?
Indeed, that the actual return made to the Register of Pecuniary Interests is made by members of Parliament. And I know it sounds a little odd when that member is a minister to say the minister, as a responsible minister in their portfolio area, is not responsible for that return. and can't be questioned directly on that return, although I'm sure experienced members can find all sorts of ways around the directness of such a question as